Oh, I'm live now. That took long enough. Reading Real Property from the Barbary Outline. On page 44, we just got to concurrent estates. I'm talking about severance of concurrent estates. A joint tenancy can be terminated by a suit for partition, which can be brought by any joint tenant. It may also be terminated by various acts by any joint tenant. One inter vivos conveyance by one joint tenant, and inter vivos conveyance by one joint tenant of her undivided interest destroys the joint tenancy so that the transferee takes the interest as a tenant in common and not as a joint tenant. This rule applies to both voluntary and involuntary conveyances, even secret conveyances. So that the transferee takes the interest as a tenant in common and not as a joint tenant. So that's your inter vivos conveyance by one of the joint tenants of their undivided interest to destroy the joint agency. A, when more than two joint tenants, when property is held in joint tenancy by three or more joint tenants, a conveyance by one of them destroys the joint tenancy only as to the conveyor's interest. The other joint tenants continue to hold in joint tenancy as between themselves, while the grantee holds her interest as a tenant in common with them. Transactions that may not result in severance. Judgment liens, one. In most jurisdictions, when a plaintiff obtains a money judgment against a defendant, that judgment becomes a lien on the defendant's real estate in the county where the judgment is docketed. This is automatic in some states. In others, the lien must be recorded in the real estate records. The lien then runs with the land, burdening it until the judgment is paid or until the lien expires under a statute of limitations, example 10 years. Suppose such a lien is obtained against one of several joint tenants but not against the others. Does it sever the joint tenancy, converting it into a tenancy in common? The majority view is that it does not. A lien is not considered a sufficiently substantial conveyance to destroy the unities of time and title. However, if the plaintiff who obtained the judgment then proceeds to enforce it by foreclosure, often termed a judgment sale, the sheriff's deed issued to the buyer at that sale will sever the joint tenancy. That follows from the fact that the sheriff's deed conveys the defendant's full title. Example, A and B own land as joint tenants with right of survivorship. P sues A on a tort claim and obtains a record of judgment. If A dies at that point, B owns the entire land by virtue of the right of survivorship, and P has a lien on nothing. However, assume that P has a judgment sale and the sheriff's deed is issued to X, who buys at the sale. Then A dies, B and X each own a 1/2 interest in the land as tenants in common. Mortgages. In the majority of states, a mortgage is regarded as a lien on title and one joint tenancy's tenant's execution of a mortgage on her interest does not by itself cause a severance. Rather, the severance occurs only if the mortgage is foreclosed and the property sold. But in the minority of states, which regard a mortgage as a transfer of title, the transfer destroys the unity of title and severs joint tenancy. Example, A, B, and C are joint tenants. A mortgages her interest to lender who reports. Thereafter, A dies and lender seeks to enforce her mortgage on an undivided 1/3 interest in the property. In a state following the lien theory of mortgages, lender loses. A's mortgage did not sever the joint tenancy. Lender's rights were lost when A died prior to foreclosure. A's interest evaporated, and with it, lender's security interest. So that's the lien theory. What's the lien theory? It's the minority. The minority of states regard a mortgage as a transfer of title. The transfer destroys the unity of title, and severs the joint tenancy. Okay, so that's the title theory I just read there. The majority of states regard a mortgage is regarded as a lien on title. So I feel like I'm never going to get this straight if they don't give me the definition of what this stuff is. So, in the example, the state was following the lien theory, and therefore the lien theory did not destroy the unity of title. Therefore, the lien theory views the mortgage as a lien on the title, only as a lien on the title, whereas the title theory views the mortgage as a transfer of title, and the transfer destroys the unity of title. So I'm going to write this down. The lien theory views mortgage as lien on title. The title theory views mortgage as transfer of title, and the transfer destroys the unity of title, severs the joint tenancy. Leases. Theoretically, when one joint tenant leases her interest in jointly held property, the lease destroys the unities of interest and possession and thereby should affect severance, which is the view taken by some states. But other states hold that the joint tenancy is not destroyed and is merely temporarily suspended for the length of the lease. Death of lesser. There is a split among the states following the latter view on what happens if the lesser joint tenant dies before the end of the lease. Some courts hold that because the lesser's own right to possession would cease on her death, so must the right of any lessee, i.e., the lesser should not convey more than she had. Others hold that the lease operates as a temporary severance, and the remaining joint tenant survivorship rights are therefore postponed until the end of the lease. Contract to convey by one joint tenant. In most states, a severance also results where one joint tenant executes a valid contract to convey her interest to another, even though no actual transfer on title has yet been made. The contract to convey is enforceable in equity and hence is treated as an effective transfer of an equitable interest. Thus, if the vendor dies before the title is transferred, the purchaser is entitled to a deed from the vendor's estate and becomes a tenant in common with the original joint tenant or tenants. Compare executory contract by all joint tenants. There is a split as to whether an executory contract to sell entered into by all the joint tenants will terminate the joint tenancy. Suppose that on January 1, A and B joint tenants contract with X to sell and deliver title to Blackacre to X on February 1. A dies on January 15th. Two questions arise. On February 1, is B entitled to the full sales proceeds as surviving joint tenant, or is A's estate entitled to one half on the theory that the January 1 contract worked an equitable conversion, which created in the vendors a contract right to receive money that was held in tenancy and power? Yeah. Okay. And second question, will X have to obtain a deed not only from B, but also from A's administrator on the theory that the retained title, legal title for security purposes was held in tenancy in common? I get it. I mean, it's basically saying if A was still alive, they'd be joint tenants. X would just take Blackacre from the two of them. And yet, since A died, A's estate, well, since A and B sold the property, okay, wrong. The whole first premise is wrong. As soon as A and B convey the property to X, or contracted to convey the property in X, they were no longer joint tenants. Which means if A died before contracting, then the whole property would have belonged to B. However, A died after contracting when it was no longer joint tenancy, it was a tenant in common. Therefore, A's heirs would take. And I really don't understand why X really cares, because A's administrator has to go forward with the transaction. So, like, will X have to obtain a deed not only from B, but also from A's administrator on the theory that the retained legal title? Yeah, they do. The first question was on February 1, is B entitled to the full sales proceeds as surviving joint tenant? Or is A's estate entitled to 1/2 on the theory of January 1's contract? So, yeah, B only gets half now. Those questions were answered, as far as I'm concerned. So, common law view, joint tenancy continues. The common law view still viewed by many courts is that a joint tenancy continues in both the right to the proceeds and the retained legal title, meaning that B gets the full sales proceeds and can give full title. So that was the common law view that clearly did not give effect to the executory contract by all joint tenants. Whereas other courts, tenancy in common, and I think that's probably still the case in Hawaii, because I'm vaguely remembering a Hawaii case that all of this was argued. Other courts, tenancy in common. Other jurisdictions, however, proceed on the doctrine of equitable conversion and hold that the executory contract converts A and B's land ownership rights to a mere contract right to receive the purchase price, which they hold as tenants in common because of the statutory presumption favoring such tenancies. Further, the legal title to the land retained for security purposes is also held to be in tenancy in common. Now, testamentary disposition by one joint tenant has no effect. So we're still talking about the severance of joint tenancy. A testamentary disposition by one tenant has no effect. That in that section, a joint tenancy is not terminated where a joint tenant executes a will devising her interest to another or dies with such a will in effect. The reason is that a will is ambulatory, effective only at death, and hence is inoperative as to a joint tenancy property, because at the instant of death, the decedent's rights in the property evaporate. The result will be contra if all joint tenants had agreed that the decedent should devise the interest, but in such case, the agreement itself would cause the severance. So, compare secret deeds. As indicated above, an inter vivos conveyance severs a joint tenancy. This is true even though the deed is kept secret, and the interest transferred is to take effect only upon the death of the grantor. However, if the grantee does not know about the deed, the grantee's acceptance after the death of the grantor does not relate back to defeat the right of survivorship. Okay, so grantee has to accept basically before the death of the joint tenant to relate back to the right of survivorship. Otherwise, it had evaporated on the death, and acceptance after death is not an effective transfer, conveyance, you might say. I don't even know what to call it, actually. gift. Effective one, joint tenants murdering another. Some states have passed statutes under which the felonious and intentional killing of one joint tenant by another joint tenant operates as a severance. In other states, the surviving joint tenant holds the ill-gained portion of on a construction trust for the decedent's estate. Thus, the homicidal survivor keeps her original share but does not profit from her felony. They also have the Slayer statutes. Anything else? Tenancy by the entirety. This is a new section within the concurrent ownership part. So a tenancy by the entirety is a marital estate akin to a joint tenancy between a husband and wife. It is not recognized in community property states, but in some common law jurisdictions, it arises presumptively in any conveyance made to husband and wife. It arises presumptively in some common law jurisdictions like Pennsylvania. Right of survivorship. The estate carries a right of survivorship which operates in the same manner as the right of survivorship incident to a joint tenancy. Severance limited. The major distinction between the joint tenancy and the tenancy by the entirety concerns severance. A tenancy by the entirety cannot be terminated by involuntary partition. It can be terminated only by the death of either spouse, leaving the survivor sole owner of the fee, divorce, in most states, leaving the parties as tenants in common from the right of survivorship. Third, mutual agreement. Or four, execution by a joint creditor of both husband and wife. A creditor of one or the other cannot execute. So, yeah. Individual spouse cannot convey or encumber. In most states, an individual spouse may not convey or encumber tenancy by the entirety property. A deed or mortgage executed by only one spouse is ineffective. Tenancy in common. A tenancy in common is a concurrent estate. And remember that none of this applies in California or any of the other 5 or so community property states. It applies everywhere else besides California. Individual spouse cannot convey or encumber in most states, and individual spouse cannot convey or encumber tenancy by the entirety property. I just said that. The deed or mortgage executed by one spouse is ineffective. Tenancy in common. This is a new section already. A tenancy in common is a concurrent estate with no right of survivorship. Each owner has a distinct undivided interest in the property. This interest is freely alienable by inter vivos and testamentary transfer, is inheritable, and is subject to claims of the tenant's creditors. The only unity involved is possession. Each tenant is entitled to possession of the whole estate. Today, by statute, multiple grantees are presumed to take as tenants in common. The same is true where multiple transferees take by descent. Incidents of co-ownership, possession. Each co-tenant has the right to possess all portions of the property. No co-tenant has a right to exclude possession of any part. The term a co-tenant out of possession cannot bring a possessory action unless there has been an ouster by the tenant in possession. A claim of right to exclusive possession can constitute an ouster. Rent and profits. In most jurisdictions, but not all, a co-tenant in possession has the right to retain profits gained by her use of the property. A co-tenant in possession need not share such profits with co-tenants out of possession, nor reimburse them for the rental value of her use of the land unless there has been an ouster or an agreement to the contrary. However, a co-tenant out of possession has a right to share in rents from third parties and profits derived from a use of the land that reduces its value, for example, removal of minerals, etc. Effect of one concurrent owners encumbering the property. A joint tenant or tenant in common may place a mortgage on her interest, but may not, of course, encumber the other co-tenant's interest. If a tenancy in common is involved, the mortgagee can foreclose only on the mortgaging co-tenant's interest. Likewise, if a joint tenancy is involved and the mortgage itself does not sever the joint tenancy, the mortgagee can foreclose on the mortgagor's mortgagor or co-tenant's interest in the foreclosure sale itself will cause a severance. But in the case of a joint tenancy, the mortgagee runs the risk that the mortgaging co-tenant will die before foreclosure, extinguishing the mortgagee's interest. The same principles apply to judgment liens obtained against an individual co-tenant. Example, A and B are joint tenants with the right of survivorship. A injures P in an accident and P sues A, obtaining personal injury judgment against A for $1,000. This judgment is, by statute, a lien on A's 1/2 interest in the land, but it does not cause a severance. If A dies before the lien is foreclosed and is survived by B, B owns the land free and clear of the lien. But if P forecloses the lien before A's death, the foreclosure sale will cause the severance, and the buyer at the sale will own a 1/2 interest in the land as tenant in common with B. Ouster. Under the unity of possession, each co-tenant is entitled to possess and enjoy the whole of the property, subject to the equal right of her co-tenant. If one tenant wrongfully excludes another co-tenant from possession of the whole or any part of the whole of the premises, there is an ouster. The ousted co-tenant is entitled to receive his share of the fair rental value of the property for the time he was wrongfully deprived of possession. Remedy of partition. A joint tenant or tenant in common has a right to judicial partition either in kind, division of the tract into parcels, or by sale and division of the proceeds in accordance with the ownership interest as modified by permitted recoupments for improvements, repairs, taxes, and the like. Although partition in kind is generally preferred, partition by sale and division of the proceeds is permitted when a fair and equitable physical division of the property cannot be made. Nordenhauser versus Christner, Nebraska, 1983. Here's 2 examples. A and B own a single-family home as joint tenants. A brings an appropriate action to partition the land. Because physical division of the home is not feasible, the court will order a sale of the home and division of the proceeds equally between A and B. So partition by sale. All right. In kind. Okay. By sale and division of the proceeds versus in kind, which is probably the second example. A owns a 3/4 interest and B owns a 1/4 interest in a 4-acre undeveloped parcel of land as tenants in common. The applicable zoning ordinance requires that the buildable lot contain at least 2 acres. A seeks to partition land into a 3-acre lot for himself and a 1-acre lot for B. B argues that the land should be sold and the proceeds divided between A and B according to their respective shares. B will prevail because the zoning ordinance makes it impossible to divide the land fairly. So again, that's a partition by sale and division of the proceeds, not a partition in kind, which is preferred because, of course, I don't like to force a sale on parties. Restraint on partition by co-tenants. Although in general a co-tenant has a right to demand a partition by judicial sale at any time, courts give effect to a provision prohibiting partition by any one co-tenant, provided that the restriction is to last for only a reasonable time. The restriction is not considered to be a valid restraint on alienation because 1. Any co-tenant can transfer her interest to a third person at any time, and 2. The restraint can be eliminated if the co-tenants join in a deed to a third person, thereby terminating the co-tenancy relationship. Expenses for preservation of property. Contribution. Under certain circumstances, equity courts will compel contribution between concurrent owners. Repairs. Contribution may be compelled for necessary repairs. A co-tenant who pays more than a pro rata share in the cost of necessary repairs is entitled to contribution from the other co-tenants in actions for accounting or partition. Although the courts are split on whether a co-tenant who makes necessary repairs can maintain an independent action for contribution against the other co-tenants, the majority view is that she can compel contribution provided she has notified the other co-tenants of the need for repairs. Moreover, several decisions authorize contribution even without such notice. A common law view was that because no co-tenant has a duty to make necessary repairs, a co-tenant who makes such repairs cannot bring an action to compel contribution from the other co-tenants. This is now the minority view. Improvements, no contribution or set off. Generally, there is no rate of contribution for the cost of improvements, nor can they be set off in an action for accounting. Only in an action for partition can the value of improvements be recouped. Taxes and mortgages. Contributions can be compelled. Each co-tenant has a duty to pay her share of taxes and payments due on mortgages on the entire property. A tenant who is not in sole possession can pay the taxes and mortgage payments and then compel contribution from the other co-tenants. However, a co-tenant in sole possession will receive reimbursement only for the amount that exceeds the rental value of the property. During a fair duty of fair dealing among co-tenants, a confidential relationship exists among co-tenants. Accordingly, the acquisition by one co-tenant of any outstanding title or lien that might affect the estate held by all the co-tenants is deemed to be an acquisition on behalf of all the other co-tenants as well. Thus, when one co-tenant purchases or otherwise acquires lien holders' mortgagees, in paren, claim against the co-tenancy property, she must give the other co-tenants a reasonable time to pay their share and acquire a proportionate interest. Courts carefully scrutinize the fairness of transactions between co-tenants. Lastly, it is difficult for one co-tenant to adversely possess against other co-tenants. Example, A and B own land as co-tenants, neither pays the annual property taxes. The county conducts a tax sale and A buys the property for $10,000. If B is willing to pay $5,000, many courts will compel A to put the property in co-tenancy again. So we've gotten the landlord tenant on page 49. And I'm going to break here.